Okay, so we start. Bene. So if the interpretation is working, I will speak Italian, because we are connected with all our networks in Italy. Ok. Bene, buon pomeriggio a tutti.
Afternoon, one and all. Thank you very much indeed for your attendance. Now, this afternoon we will be talking about international trade and the ideas that the five-star movement has on what might be a new vision of trade. We set in train a series of meetings a few weeks back. We started in Rome with an initial introductory meeting on economic development, the idea being to act further down the line to discuss our development program in the five-star movement. And having looked into the various different views on the different topics, we decided to filter out a number of aspects on economic development, and we thought it apt to talk about international trade. It goes without saying that the idea of trade engaged in by a state engaging in elections must perforce have an international vision and a European vision, since the rules of trade are decided almost exclusively at the European level. In a historical phase like this, when the EU has shifted towards neoliberalism quite drastically, and vested economic interests and multinationals are really calling the shots, so it behooves us to think carefully about how international trade agreements are working today, what the rules of trade are, and to see how these can be adjusted, tweaked, changed and revised to make them different. We would like to leave behind us the idea that there is no alternative. The five-star movement thinks that there is always an alternative to everything, even when it comes to very ticklish and interconnected issues, such as those involving various states. We need to be able to take a hand in matters and have our ideas straight. That's precisely why we have convened this meeting. We'll be dealing with the issue of trade with three different panels, in which we will be talking in great depth about various facets of all of this. I'll just switch off one of the two microphones. So we'll be dealing in depth with various facets of all of this, starting with international trade agreements. We will talk with people who have worked on this program. We will hear about things from the horse's mouths. We'll talk about the national stance of Cinque Stelle. We have various Italian members of parliament, and Tiziana Beghin. Barbara Lezzi was invited. She's a senator, but alas, she could not come due to a last-minute unexpected event. Those of us in the committee working on this are trying to look in depth on the issues, and then we'll go on to work on our program. We have various experts, university professors, renowned personages, and also representatives of other political groups who will talk in the second panel, when we will talk about those trade aspects linked to reports already signed off on in the EP. I will now hand the floor over to a person who has really been at the forefront of the struggle in our committee in the EP. In other words, Tiziana Beghin, who has really set her shoulder to the wheel on the issue of international trade, starting with TTIP and CETA first and foremost. And she's dealt with all of the reports which have been voted on thus far. Over to you. Thank you, Ignazio. Thank you to our guests who will be speaking throughout this afternoon in a bid to exchange views with you. I represent the five-star movement. I'm proud to do so. I'm very fortunate to have represented it for almost 3 years in the International Trade Committee. When I joined the Parliament, one of the first questions I asked was this: what is our rationale on international trade in the five-star movement, having heard the various debates and looking at the projects which have been pursued to date during my term of office? I've become more and more convinced that for most people, international trade is a goal in and of itself for its own sake. We don't think that's quite right, because the goal is not trade. Trade is the route which can lead you down different paths towards different goals. These goals are more prosperity, more equality, more social progress for all stakeholders in the various negotiations. That's a very important distinction to make. It is not always picked up on, because the indicators of a success for a treaty rather than an agreement more often than not are the actual results we would expect. Regard is only given to the ups and downs of trade exchanges. That's the backdrop we're working against. As a political party, we dug our heels in from the start. We want to defend trade in order to pursue these noble goals. We look favourably upon trade, since we want to attain these very sound goals. We are against certain forms of trade, as Ignazio just said, some forms of trade whose goal is extremely neoliberal, where there is no protection for citizens and consumers or workers. This protection is not guaranteed. We're talking about trade agreements, just to be clear. Now here, the first major topic we dealt with was TTIP and the like. On TTIP, we managed to take a hand in matters, quite a decisive hand at that. When it comes to what the negotiations were geared towards. A sterling work was done by us with other political groups, also with the assistance of civil society, because we wanted to lay down some parameters. Now, TTIP is somewhat outmoded after all the upheaval after the American elections. It seems that seems that less interest is being shown by our US counterparts. We cannot say likewise for the Europeans, who are still dead keen on these kind of negotiations. So what do we not find particularly persuasive in these kinds of trade agreements? So these so-called deep and comprehensive trade agreements, here we're dealing with things which affect citizens' lives across the board, and these agreements have a key economic impact. There are three main arenas as to why TTIP and CETA and the successive trade agreements further down the line, why do we not find them persuasive? Well, let's look at the effect on citizens' lives. Trade must be a tool to attain goals. In other words, greater prosperity, greater wealth, and more benefits for citizens. These agreements, whose aim is to standardize or indeed harmonize matters in very different countries, as the Commission often says, that does not guarantee any improvement, because there's no guarantee that living standards will go up. At the start of the process, when very few people had access to documents and you had to go to the reading room, we had very few reassurances which did not satisfy us. Technically speaking, it's very difficult to get your head around how you could harmonise such different systems based on very different approaches, such as the science-based approach in the US compared to the precaution principle used in Europe. Maybe you're not all experts on this issue. I'll explain these different approaches. I'm aware that people are watching us on streaming. According to the science-based approach, in very broad brush terms, you can market a product using substances or components whose harmlessness has not been scientifically proven. However, when it comes to the European system, using the precautionary principle, any reasonable misgiving as to whether a good or a product might be harmful needs to be reported. If you cannot prove that the process or substance is not harmful, then this can't be used or rolled out. These are two very divergent approaches. That's why there are enormous differences between the US and Europe. So there's no hindrance to harmonizing technical systems. For example, standardization of motor vehicles. There are different protocols in place, but that's no impact on lives of citizens. That's a different kettle of fish from when we talk about chemical products, which are used in many different fields, from farming to cosmetics. That's a different kettle of fish than the food stuff sector, which is very sensitive for us in Italy. So we are very exercised by these standards. We have no assurances as to these standards, and we had leaks from Greenpeace, and the lid was lifted on other matters by other stakeholders. When it comes to risk for public health, we could at least expect protection for SMEs, which are the very backbone of our economy, both in Europe and specifically in Italy, if we want to whittle this down to national level. Nobody has a crystal ball, and nobody can really predict the trickle-down effects of trade agreements. There is so-called workers' consensus. I'm from the world of business myself. Throughout my life, I've worked in various companies. I was a business analyst, in fact. But studies which are published by the Commission give us no real grounds for hope on TTIP and CETA, for example, where economic growth estimated is 0.00, etc., etc. So that's virtually zero growth, clearly compared to zero growth. The major interest which has caused many multinationals over the past 2.5 years to bring pressure, a lot of pressure, to bear on the outcomes of these agreements. What we really have is a redistribution of a saturated market, which gives no hope for growth. But market shares will just shift from one operator to the other. Now, these agreements just redound to the benefit of multinationals and conglomerates. It's a different story for the small and medium enterprises, the SMEs. They do not have the funds to expand to the US market, and they have everything possible to lose from competitors on the domestic market, as we can see in the relevant studies. Official studies speak plainly when they say that an agreement like TTIP could have an effect on trade diversion to the tune of 25 to 30%. This means that our SMEs are operating in a market which is mislabeled international. If an Italian sells goods in Germany or France, that's the internal market for us Europeans, of course. But for our entrepreneurs, and I know them very well, our entrepreneurs may be completely sidelined by competitors from across the Atlantic in the case of TTIP. Less so from CETA when it comes to the size of the market, but it's still a slippery slope. Since 40,000 US companies are based in Canada, and there's also the issue of NAFTA, which might kick in over the course of negotiations. However, on CETA, we have a great deal of misgivings. These kinds of agreements do not protect SMEs, even though the opposite is claimed, even by the governments. Government ministers responsible for this arena. We're talking about people from a very hyper-liberal background. The market at all costs has not led to the right results. That's not what it says necessarily in the studies, but that's what direct experience teaches us for SMEs. It's not only the free market is not the sole problem. but the SMEs have a tremendous problem in terms of competition. People thought these trade agreements were the answer to everything. I mean, that was intellectually dishonest to claim that less than 13% of companies in Europe conduct international trade, so outside the bounds of the EU. This is not purely down to the legislative difficulties in place and the ignorance of systems elsewhere. I mean, I've worked on this on the ground. If a company today does not trade in the US, more often than not, it's because the company is not able to do so, because the distribution systems in the US completely differ from ours. Our SMEs are often very specialized and very local. They deal in very small volumes of products, so these SMEs are not able to penetrate the US market according to the US rules. They could do so in certain niches in the market, which would not need an instrument like a TTIP, which is more harmful than anything. And it's also a question of funds. If you want to win market space in the distribution system in the US, that needs an enormous amount of dough to be ploughed in. So a host of SMEs in Italy are already conducting trade with the US, and they could enjoy advantages. I talked to them about the pros and cons of an agreement like this, and they say, look, we aren't getting any benefit whatsoever. This is no encouragement for them to pursue trade with the US. Now, quite aside from purely economic issues, I'm aware the clock's ticking, but I do tend to waffle on a bit. Now, we also have to look at the laws and standards in place. We need to talk about these. I mean, we've invited experts from the world of business along and representatives of civil society who will tell us about their concerns. There is an essential topic to be dealt with as to how investments are protected. That means foreign investors are in a position to stick their noses in and bring laws into place in member states as the SDS clause, which has been recast. This means that large-scale economic operators are able to bring influence to, and have their economic interests protected. And this means that economic interests are privileged over and above the interests of the state, which will be on the back foot, as will local economic operators. Outsiders can bring pressure to bear on local and national governments. And it's the citizens who will lose out for this and various other reasons. Our stance on this agreement is extremely critical. We aren't necessarily levelling criticism at trade as a whole. I mean, throughout this meeting we will hear various less controversial contentions about these kinds of agreements. I want you to appreciate the tremendous amount of work we've done to ensure that trade is geared towards attaining the goals we've set. So we've tried to provide an answer to Ms. Malmström's Trade for All. I'm the rapporteur on the topic. She's taken this rather simple stance, but we've taken a more constructive one within the European Parliament, and I'm proud to say that we got a majority behind us on that one.
Grazie.
Well, thank you very much indeed, Tiziana. Thank you for your explanations. When we're talking about trade, you are quite right to say we're not against trade per se, but at this historic juncture in our history, you can't draw a dividing line between those for and against trade. I mean, it's not a question of going back hundreds of years in time, but there are different alternatives, and there are ways in which trade can be regulated in different ways. And I think the idea is to look at the line to take when it comes to a well-functioning trade in the future, rather than bringing everything down to the lowest common denominator in terms of workers' rights, consumers' rights, and so on. So we'll be alternating between political presentations by the EFDD and other groups, and more technical presentations. Léa Offray is our next speaker. I hope I've pronounced your name right. She represents the European Consumers Bureau, BEUC, here in Brussels. So she'll be looking at this from the consumer's angle, the effect on consumers, and the implications of treaties such as TTIP and CETA for consumers. So over to you, Léa.
Thank you very much. And I'm going to switch in English if it's okay. So thanks a lot for the opportunity today to present to you, well, the European consumer view on this very, very important issue, which is trade. And trade now, we all know that is going a little further than the traditional sense of trade. So indeed, I'm Léa Offray, and I'm leading the trade work at BEUC, which is the European Consumer Organization. BEUC is an umbrella organization representing 43 consumer organizations in 31 countries. And for instance, we have 2 Italian members, which are Altro Consumo and Consumatori Italiani per l'Europa. And so, I mean, I think we are on the same line here, because traditionally, consumer organizations are in favor of free trade and also a free trade agreement, but only if it is well designed. And when I say well designed, what we have in mind is that we want trade agreements that benefit consumers, but also that protect them. And now, I mean, we are also in the line of being more and more critical with new modern trade agreement, because the scope is completely changing. So which is why we've become critical towards the negotiation between the European Union and the United States on TTIP, and also for the first time we had to game against trade agreements, CETA, so the agreement with Canada. And so first today I would like to explain to you what is at stake when we are talking about trade for the consumer perspective, and then indeed what could be the alternative, what could be a good framework that can work for consumers on trade agreements, but also other issues that are in trade agreements and maybe should not be in trade agreements. So, as I was saying, on the part of what is at stake for consumer, well, first, the thing is with TTIP, with CETA, but also with the Trade in Services Agreement, and with all this idea that was brought during the Trade for All conversation, which was very important here in this parliament, is that we're no longer talking about traditional trade, so reducing really the barriers to the market access, so reducing custom duties, creating quotas. We are talking now in the context of TTIP or in CETA, but also governance issues. So for instance, now we can see in these negotiation and even agreements provision on regulatory cooperation, good regulatory practices, and also provision to protect foreign investors. And this is where we have a problem, because if it's not done carefully, this could bring harm to consumers. If I take the example in TTIP, so between the European Union and the United States, what brought us to really work on this issue as a consumer organization was when we saw the first text on regulatory cooperation, and also all this discussion on good regulatory practices. Because also we are a member of a network which is called the Transatlantic Consumer Dialogue, which brings together more than 75 organizations in the European Union and the United States. And what our US colleagues have told us on the side of consumer is that we should be very, very careful of the pressure of not only the US industry, but also the US administration, so previous one and the new one also, on this issue of having access to legislation as early as possible to be able to influence it. And this is where we have an issue, because of course it is good to have regulators talking to each other, because this is how they can make the market safer for consumers. So it's a good thing. But if you put that in a trade agreement with the primary objective of making sure that it's going to make trade easier, it's not the same thing as saying like you should talk to each other to make the market safer for consumer. And then you have also all this discussion that, is it really a dialogue between regulators, or are we trying to influence each other's law? Because this is where we have to keep a policy space. It's really important, because it brings this whole idea you were mentioning in regards to the ISDS clause, this regulatory chilling effect, this risk of bringing that. So which is why we were very critical during the negotiation with the United States, and when we said like we really need concrete safeguards to make sure that it's not going to happen, that we won't have indirect pressure, but because of course you will never see in an agreement, in a trade agreements, well, we just agree to lower standards. We know that it's not going to happen, and we know that it might not even be the intention. But then with the application in the long run of this dialogue, if it's not done carefully, you could see a lowering of, I mean, it can be product safety standard, chemical safety, food safety, etc. So this was very important for us. And if I take now the example of a trade agreement that is concluded and that might be implemented soon, CETA, so the agreement with Canada. And this was very surprising for the consumer movement, because it's the first time that we had to say, well, no, we cannot support this agreement. It's not possible. Because in CETA, the big red line for us is when we saw, well, the new chapter on investment protection. So yes, the new model, investment court system, is still an improvement if we compare it to the old investment state dispute settlement mechanism, ISDS. But still, a foreign investor can have the possibility to bring a claim, or even to threaten to bring a claim to get compensation, let's say to Italy, for instance, if Italy wants to adopt a new consumer protection law, or if the EU wants to. So here there is a risk of what I was telling you about, like the regulatory chilling effect, where the state or the EU could say, well, I'm going to lower the ambition of my law, or maybe I'm going to even forget about it and not going further because it could be too risky. This is not acceptable. What we said since the beginning to the negotiators is that you need to have an exclusion. It should not be possible for a foreign investor to sue the EU or states if it's in relation with the consumer protection law, but it should also apply to any public interest law, so regarding health, regarding environment, social protection, labor protection, for instance. So which is why we also, despite our traditional support for trade, we had to say, well, this is not something we can support, and we do not call our MEPs, for instance, to ratify this agreement. And now our members nationally are also working on this issue for the national ratification. And you know also, I mean, when we talk about what is at stake for consumer in trade, it's not only about the risk, but also what we see in this so-called new comprehensive trade agreement is that we don't really see consumer at the heart. So indeed, the aim is to make sure that it's going to facilitate trade, but we do see an advantage for the private interest compared to the public interest. Because, for instance, it should also be about bringing tangible benefits to consumer. Because, for instance, with CETA, we are told, well, look, wait a little for the implementation of the agreement, and you might see some benefits for consumer in the long run, but we have no really, really well done impact assessment, etc. of this. And it's not only about reducing the prices for consumer, giving them more choice, it's more than that. It should be also about giving them really concrete benefit that they can see in their everyday life. And this is where I want to talk now about the ideal scenario, the alternative you were mentioning, what could work indeed. Well, from a consumer perspective, we really think that first, we should do kind of a division of what we're talking about here. Trade should maybe focus back on trade, and it's not a step back to think like that and being against the progress and etc. On the contrary, it should be like we should focus on what's important. So maybe the issue, for instance, of regulatory cooperation, which is, as I said, very important, well, maybe we should have it outside of a trade agreement, because then when regulators will talk to each other, it will happen with an objective that is not primarily to facilitate trade, and it will change the overall thing. And then we will have also safeguard to make sure that we will not have indirect pressure to change the legislation. So it's just another way, another philosophy, if you like. So this should be dealt like this. And also, I mean, we should not have this possibility for foreign investor to attack state. I mean, it's a flat-out no. This is something that we do not want to see in trade agreements. But what we do want to see in an ideal trade agreement, for example, would be like the objective should be, yes, let's facilitate trade, of course, but also let's bring benefit and protection to consumers, but also to workers, to the environment, to protect health and etc. So this should be, we should have an equal objective on this, not only facilitate trade while protecting etc. But it should really be the same objective on the same level, because then we are changing also the picture. And we also need to see concretely written in trade agreements safeguards. This is really important, as you mentioned. This fight against the precautionary principle and the science-based approach is never going to stop. So we really need to see written legal safeguards in the text. And it's the same when it comes to data protection. We can see now a huge pressure in trade agreements to deal more and more with the issue of data flows. And this is very sensitive, because here we're talking about a fundamental rights for EU citizens. Their personal data must be protected. And for this, we need to see something very strong in every trade agreement, really rock solid and inattackable, either by a foreign investor, but also by a state. This should be really important. And then I was talking about this issue of bringing tangible benefits to consumers, and this is something, a narrative that has been evolving recently also here in the European Parliament, and it's very important to continue like this, because it's not only, as I was saying, about reducing prices and increasing choices. We should imagine that trade agreements could create, for instance, the political will to make sure that consumers will have access to more affordable telecom market. Let's imagine reducing roaming fees, for instance. Why not? We can also imagine reducing the geo-blocking practices. Or also, there is an issue that is never taken into account in modern trade agreements, is that consumers are not necessarily aware of whether or not, as EU consumer, they will be protected by their EU consumer rights. If they buy, let's say, a service of a product in the United States, but it can also be in Japan, their EU rights will not necessarily apply. It will depend on a series of factors. And they should first have the information on that, and then they should know what they can do if there is a problem after they buy this product or this service, and they should be able to get compensation easily. This is how you can make also trade easier for consumers. So this is something that we want to see. And on the side of regulatory cooperation, and also on the other side, so trade, both processes, they must be transparent. As you were saying, this is very important, and there is progress, of course, we've seen it, but we need more. And this must be, the both processes, transparent and accountable. We need to see that it's done in a democratic manner. This is key to bring trust to consumer. And just to, as we are also in the process of thinking as the consumer movement what we could do and what we could ask for trade, I think that the role of your party can be very important here, and to bringing this possibility of an alternative and to bringing the necessary political impulsion to create the changes to achieve this goal. Thank you very much.
Merci beaucoup, Lea.
Thank you very much, Leah. And now Tiziano would like to add something. Yes, we've received some news which I think is worth sharing with you, particularly as we're talking about citizens' possibilities to have an influence on this agreement. We've had a ruling from the Court of Justice of the European Union annulling the Commission's decision to declare inadmissible the Stop TTIP initiative. The Commission had said it didn't have competence, but now the court has declared the opposite. So this is great news, absolutely fantastic news. and for good reasons. It confirms the validity of the citizens' initiative, which is the only way in which citizens can have an influence on European policy, and it debunks what the Commission was saying. The court's position is very different to the Commission's position. It stresses the fundamental role of citizens' democratic scrutiny and control, particularly when the very basis of the European Union is being amended by such trade agreements. So a very important set of principles has been affirmed. Thank you very much, Tiziana. And we applaud this great news. I'll now give the floor to Giorgio Sorial, who is our spokesman in the Parliament, in the Chamber of Deputies. We've worked with him on economic development in the Chamber, in the Senate in Italy, and in the European Parliament. We've worked with various members on committees so that we can have a contribution to the discussion and to our program. So Giorgio can tell us a bit about our thinking on trade. Thank you very much indeed, Ignacio, and thank you to all of you for being here and everyone who's tuning in. We're talking about trade, and every time I talk about trade, the fundamental question I ask myself is, trade in what? Because otherwise we keep talking about trade in terms of trading goods and products, which have changed a great deal over time. And there's someone we know very well who often says Denmark today exports thousands of tons of biscuits to the US, which exports tons of biscuits to Denmark. Who's eating the biscuits? Well, they're probably different biscuits. So why don't they just exchange the recipe, trade the recipe, rather than all those biscuits? So that's just food for thought. When we're talking about trade, where are we ending up? I think we see a very different paradigm. We're talking about trade in finished goods and products, a linear system where the aim is the products have a certain lifespan. They're designed in that way. These products invade the market. They don't really follow the supply and demand curve, but they really invade the market. They're distributed not just on national markets, but on international markets. And many of the products not sold or traded, even though they haven't been sold, end up being waste. They end up on the shelves, they lose their value. They cannot be sold for the selling price anymore, and then they're sold at such low prices that they're basically just waste placed on the market. It's not a question of getting a proper margin for the producer. And I think we need to think about striking a balance in this paradigm between trade in products and a new consumption culture, because if we talk about trade without talking about changing the way the average consumer thinks, I think we'd be making a major error. We continuing to produce goods which come from raw materials. That's the first step. Then they're designed, produced, distributed. It's a linear model with the work we're doing on economic development, we're trying to understand what are the barriers which many companies face in trying to bring in a circular process, though there was some European legislation on that. At national level, there are barriers impeding companies from doing this, and it's also a question of technological design of products. So this is one reason why over the years in the Italian Parliament and in the European Parliament, a lot of questions have been asked about this, and we've been looking at how we need to promote policies which go towards a paradigm shift. So we've been looking at all these sectors so that we can tackle them head on. And the first thing we need to do is that we have to remember that trade is a form of exchange which allows us to create social well-being in all countries rather than wars between SMEs. I come from Brescia in North Italy, where there's a cluster for the production of certain products in the mechanics sector. There's been a bit of a war between SMEs. They're all fighting for a toehold in the same market, and instead of a single market, we saw a battle between the poor, and we need to look at the specific features of the market itself and bear in mind that we cannot place so many products on the market that in the long term this will be disadvantageous to the citizens themselves. A lot has been said about TTIP and CETA and the other treaties. When it comes to national trade policy in Italy, what is being proposed by the five-star movement, we're always talking about made in Italy. Ever since I was a child, we've been talking about this. When I was a child, I didn't really understand what everyone was on about. And then we found out that beautiful belts by Italian fashion houses were only 20% made of Italian materials. And we've tried to set up a real committee of inquiry on counterfeiting and do some work in the agri-food sector as well. But I think basically what we've seen is just a snapshot of the situation without consequences being taken, without people being taken to court, and without tackling the phenomenon of counterfeiting of agri-food and other products. The Commission of Inquiry has been an end in itself, really. And then we've been talking about parliamentary work which has been submitted to parliamentary committees and elsewhere. And we've been looking at competitiveness on the trade front. Every time any product, any industrial product is placed on the market, the assumption is that this product should be safe and guarantee proper security standards are complied with and should not harm the physical integrity of the user. Now, this isn't something that's very well defined. If we look at Article 41, A1-2 of the Italian Constitution, there is a mention of safety. We're talking about physical integrity, but we don't focus on the fact that there are certain social issues created by these products. And if we look at 172, our piece of legislation which implemented the RAPEX alert system, this really didn't define the negative impacts that the placing of these products on the national market might have. Another point we often underestimate when talking about trade is the issues around the arms trade. 25 years ago, a law was passed banning the export of weapons to countries at war or where there was a conflict with Article 11 of the Italian Constitution. The legislation in question is Law 185 of 1990. And over the last few years, other initiatives have come about, and the Italian government hasn't really taken action to stop the export of weapons to countries which are guilty of serious crimes under international legislation. And obviously these arms damage the people who handle them and those who they are targeted against. And the Italian government hasn't promoted any initiatives which would really stop the export of arms to such countries guilty of such crimes. We're here to talk about the national policy of our country, and the Italian government should straight away suspend any activities involving triangulation when it comes to the arms trade. I'm speaking personally here. I come from Brescia, and I know that one of the biggest companies, one of the exporting weapons in the world, recently lost an order for guns to the US. These were to be used by the police, but it continues to export arms, the Beretta, which is made in my neck of the woods. And so we see economic development being focused on, but not the interests of civilians and citizens. So that's on the trade side. The other issue I'd like to talk about is the new consumer paradigm. How do we create a new culture for consumption, moving away from the linear model? We're seeing so many products invade the market, and that inclines us to think we need to consume all those products. There is one essential point, which is combating built-in obsolescence of products. It seems impossible to believe that there are still companies saying that the products they create should have an end-of-life date, a clear end-of-life date, and they can't even be repaired. And this runs entirely counter to any discourse of sustainable development. And when it comes to trade in the public arena, there's a need for transparency and clarity. The Bolkestein legislation does have an effect on seaside establishments and others. And this is a particular Italian feature. If we discuss such directives in Europe, we cannot neglect the fact that in Italy, our situation is very sui generis. And then coming back to the issue of consumption and consumers, there was a battle fought by the MEPs on traceability of products, and indirectly this helps to combat counterfeiting. We applaud these efforts. So the idea is for consumers to adopt a different consumer culture and to start thinking along very different lines. It's a real paradigm shift. And it's not just a question of creating a particular culture, but imposing an obligation on certain processed products that they be clearly labelled with a stringent liability system. This is what we've been lacking in Italy. You can lay down various obligations on the production and distribution side, but if you don't have a liability regime, if it's not clear who's responsible and who would incur a penalty, the obligation in countries where people try and rather conceal things or do conjuring tricks, this really won't work. So we want to have a real regime imposing liability, and obviously this is something which does impinge on the Made in Italy label, but in others as well, so that products can be properly identified. For those reasons, we've been doing this work on economic development. We're doing this in the Chamber of Deputies and the Senate in the Italian Parliament, and we're working now with the European Parliament. I'm very happy to answer any questions you may have. Thank you very much indeed.
Bene, grazie, Giorgio.
Thank you very much, Giorgio. Now I'll just check with the technicians whether we can hook up with Mr. Casabona. He was meant to hook up with us via Skype from Taipei, where he's carrying out research at the university, so we'll try afterwards. We have had some gremlins in the works. He was meant to go into some depth on the clauses in international trade agreements, such as the ISDS clause and so forth. We'll see if we can hook up with him later. Whilst we await the resolution of these technical problems, I think we can turn to the second panel. Mr. Buchner has rolled in, likewise Lola Sanchez. In this second panel, we will be taking political stock of agreements which have gone through Parliament or are in the pipeline. We need to realise that compared with the past, and Giorgio, you don't often join us here, but we need to bring each other up to speed on what's happening here. And of course, we've got a few hundred people listening in and watching on streaming. In this term of office, there's been a shift in trend in the EP. Previously, the idea was for there to be mandatory provisions in place to protect trade on an equal footing. There was the issue of conflict minerals, for example, which Tiziana will talk about later, and also the clothing sector, which Lola Sanchez will talk about. She's rapporteur on that. We'll also talk on human rights we'll talk about that with Mr. Buchner. I will also talk about the reports we've signed off on in this term of office. There's been a change, you see. Previously, there was a kind of ideological rift between those who considered any kind of imposition on companies to be interference in trade and interference in economic growth by the EU, as against those who wished to pursue a fairer kind of trade. In this term of office, what we've been seeing is a change in mindset, because more than likely people have grasped that fairer trade based on sound production rules when it comes to clear infringements of human rights, which happens in various countries, also has a detriment to the European market. The idea is not just to impose things on companies producing in developing countries where human rights are not complied with as much as they are in the EU. The idea is to protect those who participate in the same market, because when we talk about trade in the EU, we're talking about 500 million people in this market. It's a very appealing market, and often even European multinationals have preferred to produce elsewhere, slashing their production costs, infringing upon the rules they ought to have complied with had they remained in Europe. So that's given rise to some very unequal competition, and that's affected the levels of production and the level of employment within the EU. These facets were deemed taboo even in the last term of office, but in this term of office we signed off in important reports, and we're working on other reports which are shifting this trend. We're now barking up the right tree. And of course, it's up to the Commission to take the initiative. But we want the EP and the Commission to realise what they have to do. That's a struggle we're conducting day after day in the responsible committees to ensure that the Commission realises what it ought to do. If we haven't got the Skype connection, we'll try. The interpreters point out that we will only be able to interpret this if the sound quality is good. This is subject to technical glitches. Good afternoon to Mr. Casabona, who's with us from Taipei. Let's go back to the first topic. The reports from this term of office. After hearing the professor, then we'll give the floor to colleagues. Professor Casabona, Associate Professor at the University of Palermo. He deals with international trade law and clauses, and he's in a different time zone in Taipei. He will explain some aspects related to clauses. Thank you very much for bringing me on board. This is a great initiative. The topic assigned to me is very complicated in legal and technical terms, and I'm going to be forthright. It's a difficult approach. There are negative and positive aspects. ISDS, the investor state dispute settlement. So international arbitrage courts are to be established to solve friction between foreign investors and the state. Where there are too many burdens in a given state, which will bring a detriment to local investment. It goes without saying that this is a very ticklish topic, and there are firm views on this. ISDS is seen as an ill because the investors are infringing on untouchable national sovereignty, and the hyper-liberalists say that ISDS is essential because it protects foreign investors and protects various stakeholders, including the state, and therefore ISDS is a vital tool, they say. So in order to break free from this circular thinking, this loop, And in order to shed some light on this very swiftly, because we don't have much time, we can deal with this issue of international arbitration on foreign direct investment. We can take two different tacks to this. The first attack is to do with a gestalt, a holistic approach. We have this ISDS, this legal minotaur, if you will. What's the general framework for this? That's the first question. Secondly, how does ISDS work in practical terms, very concisely? For many decades now, with more and more globalization, national sovereignty has been drowning in a crisis because the state is no longer the only regulator. It's no longer the only one laying down the laws and rules. It's not the only party seeing to compliance. We have public and private stakeholders dealing with rules at different different strata, transnationally, internationally, and globally. So plainly, the nation state, whether we like it or not in political terms, I mean, we can look at this also in economic terms, positively or negatively, but national sovereignty is just one component part in a much broader mosaic where we are seeing overlapping provisions and lawgivers which complement each other on a continuous basis. We have a number of players on the global stage in international trade who are setting up a number of rules. One player is the EU, subject to, which has a tremendous influence on national sovereignty by dint of the treaties, but there are also private players. We cannot deny the important regulatory role by the so-called ex mercatore. We have many rules to be observed throughout the globe. This is we're not talking about a trickle down from the transnational to the sovereign level, but in the opposite direction. So this is the overarching governance framework. This was mentioned by our colleague in the first intervention. We have a centrifugal tendency. This system of governance is also parajudicial governance. What do I mean by this? There are international courts, but also international arbitration courts, which have a significant influence, or at least potentially so. They have an influence on regulations and standards imposed on society. Now, given this global village where we have these overlapping legislations and these overlapping stakeholders and this plurality of players who construe and roll out rules and see to compliance, this is where the ISDS clause kicks in. The ISDS involves the International Arbitration Court. There are different types of this kind of court which follow very different rules of procedure. So we're talking about ISDS in very broad brush terms, and in so doing we may end up barking up the wrong tree. But these courts are subject to a number of organizations, first and foremost the UN, but more significantly the World Bank, most controversially. And the ISDS model is very sweeping. This has given rise to a number of problems. The ISDS clause, generally speaking, and the setting up of the International Courts of Arbitration is a response, or was a response back in the day, and still is a response to a plausible and reasonable demand. The idea being to remove foreign investors from the influence of a given estate who might be trying to nationalize a given sector, thereby expropriating a number of production activities. Now, the answer to this response from the state compromising foreign investment, and this has happened fairly recently. This response is initially diplomatic. The investors, the multinationals, the corporations, whoever, turn to the state of origin and ask for diplomatic protection. So, having played the logic of diplomacy and international relations in play. So the reaction could be zilch, and the investor completely loses out, or there may be a number of reactions such as blackmail or military action. So the protection of the foreign investor within the scope of these clauses is not necessarily protection in peaceful terms. This is subject to different political flows of thought which may lead to violence. The new development of the international arbitration courts was this: it gave a tool to foreign investors in order to demand compensation for loss due to a legislative or administrative measure enacted by a state which is of detriment to the investor. Clearly, there are pros and cons. The advantage is this: basically, the foreign investor does not have to turn to national courts. We have to set this straight and stay reasonable. If well, we do have tremendous problems with foreign investment. If they have to have recourse to national courts, and if the court of first instance ruling does not appear for a number of years, the foreign investor changes approach. So the court of arbitration is speedier, is more immediate, and is not subject to political and diplomatic pressure. So this issue of the international arbitration courts, as so often happens, has changed its appearance in part. Some people think that the protection of investment or the legitimate expectations of investors being protected is sometimes seen as absolute. It seems there's an absolute guarantee for the investor that there will be absolute economic stability for them, and that's rather exorbitant. I'll give you some tangible examples. We have a number of arbitration rulings which have potential negative impact not only on national sovereignty but also on fundamental rights. For example, after Fukushima in Japan, Germany decided to forsake nuclear energy. Now, I think it was a Swedish multinational went to one of the many international arbitration courts and took Germany to court because this compromised investment in the management of nuclear power plants in Germany. This role was played by this multinational. The situation was tremendously compromised in Quebec in 2012. Well, Quebec had decided to temporarily suspend drilling for natural gas due to the possible release of toxic gas to protect public health. And it was taken to court for damages by a number of multinationals who had the concession to drill in that area. Now, the situation is that bit more ticklish in states which have bargaining power in the political and economic context, or have rather very little bargaining power. In Mexico, back in 2009, compensation of $70 million US was awarded to an American company which produced soda drinks, because they introduced a tax on a certain sweetener. The tax was there to discourage the consumption of very sugary or very sweet drinks. So the policy was there to protect public health. Now, just to give you an overall view of what might happen in Egypt, I think it was at the turn of the millennium, a French company obtained many millions in compensation because the Egyptian government had introduced a law on the minimum wage, which raised the minimum wage from 14 to 600 odd Egyptian lira. This increase in the minimum wage allegedly undermined the interests of the multinational. The legitimate expectations of the investors were apparently compromised. That was the allegation. What happens here, in the context of these international arbitration courts, what we've seen is a legal drift. A great deal of creative spark has been shown in terms of construal of the idea of compensation. Just bear this in mind. I was very much thrown by this. The Economist in 2014 published an article on one of these bodies under the World Bank. They wrote about one of the international arbitration courts, claiming that it was a tool to squeeze a compensation out of a body, to fight policies harmful to certain multinationals. That was the claim from the Economist, which is a very upstanding journal. It's not an anti-globalization protester. So critical voices were heard. People were critical about getting rid of the ISDS clause. People claim there needs to be a reorganization, a rejigging of the limits in terms of transparency. When it comes to the international arbitration courts, there's been an increase in transparency vis-a-vis those who enter the arbitration procedure. We know who the judges are and who is bringing the case and where they are. But often the rulings of the court are still hush-hush. Furthermore, these rulings are often not subject to appeal. The court under the World Bank is a very difficult character. Basically, it's a closed system where there is very little transparency, where people pursue many millions in compensation, but the rulings cannot be appealed, or only in very few cases. The basic idea is this, and I'll round off on this, because I think I've used all my time. Of course, it's a very complicated issue. I know that we've got the CETs and these stable arbitration courts. I'm just taking a broad brush approach here, but there are some criticisms to be levelled. The issue is not really with elimination. If that were to happen, we would throw things out of kilter. The investors would be jerked about, and they wouldn't have the right tools at their fingertips to defend their investments. So I firmly disagree with a colleague Offray. But limits could be laid down, limits when it comes to access to these courts. For example, when you have administrative or legislative or legal measures which are taken to protect the public interest, this could be one of the limitations. Tweaks could be made to boost the transparency of these tools. The issue is this: we need to see to it that these international courts of arbitration are the right tools and strike the right equilibrium between economic interests of international economic players and national sovereignty of the various states who pursue policies in the public interest. So in this international arbitration court, we should not see them acting in a willy-nilly fashion.
Sì, bene. Grazie al...
Right, thank you very much, Professor. I think the link worked pretty well, actually. We managed to sort it out in the end. I think we overrun by a few minutes, but I think it had to be done. We've understood a lot more now about the ISDS clause. So we'll end that link, thanking the Professor. Now I'll give the floor to Tiziana, and we're going to move on to the next panel. Thank you very much, Ignacio. Thank you, Professor Casabona. I'd like to welcome our colleagues who've joined us, Mr. Buchner and Lola Sanchez. So now we're going to be talking about the importance of fair and sustainable trade, looking particularly at global value chains, supply chains. In an interconnected world, it's clear that most of the things we now possess form part of a very long value chain, and often our countries only get the very last bit of the chain. So I think our aim is to foster inclusion and cooperation. I'm in favour of a paradigm shift at all economic levels when it comes to competitiveness, which was focused on over the past few years rather than greater convergence. But I think this convergence is being seen as necessary even at the grassroots. It's impossible for people to maintain such high levels of competitiveness. We've worked a great deal on a plethora of reports. We've worked in a cross-cutting way. I think it's really worth focusing on some of them. First of all, I'd like to mention conflict minerals. And I think there was quite a battle raging when we were discussing that. There was a lot of disagreement with colleagues from other political groups. We talked about this because it's such an important issue. Almost all our products contain some of these minerals. The European Commission's proposal focused on tantalum, tungsten and gold, and tin as well. And from tantalum you get coltan, which is almost in all mobile phones today. So the proposal made was to have a voluntary system, and companies are moving in this direction. They're moving a bit closer to CSR, but they're not always looking at achieving objectives, but just improving their image and their position on the market. And sometimes there's a bit of a backlash. And a very onerous proposal was made, which was really focused on the big companies. I don't know if you've read it, but it was quite burdensome, and we managed to reach a compromise, i.e. making these minerals traceable, these minerals which can be imported into Europe, and have come in without being stained by the blood of thousands of innocent people. And this is linked to other phenomena such as migration and so on. So a lot of different issues are involved, and they're far from marginal. We know from the Ivory Coast there are massive deposits which are greater than the oil deposits of Saudi Arabia. But we managed to come up with a system of obligatory traceability, but which excludes the smaller economic operators who would have had major problems with this sort of burdensome legislation which is so difficult to apply. I mean, gold for dentists, for example, that might be imported in very small quantities by small operators. So we think this is the right guidance for an industry, and this is all part of a global vision. It's not a question of trade producing disastrous results when it's used as a tool of policy, which it has been replacing a conflict, thankfully. And here I'd like to give the floor to Lola Sanchez. She's in the International Trade Committee, and we've often worked together there, and in the DEVE Committee. She's a very active member, and she has achieved some of the results that we've seen achieved, particularly in the garment sector. Lola, over to you. Thank you very much indeed, Tiziana and Ignacio.
I don't speak Italian, so I will speak in my English. Okay. To start, I have to say a good news, but maybe you are knowing this now because now it's in the media. It's just released, a press release from the European Court of Justice. Sorry, because I was not in the first panel, but you talk about it.
We received.
Yeah.
You can repeat because we have different people that listen to us and connected. So I think it's a good idea to repeat the news.
Yeah, so yeah, for sure, this is a super good idea for the European citizens that the European Court of Justice has said that the Commission has not done well when they rejected the European initiative with 3.5 million signatures from citizens against CETA and TTIP. So well, we have now to check and to see what does it mean to the process of the CETA and to this unknown process of this chill TTIP that we have now in our wardrobe. So let's see. But at least this is a very, very good idea. We have to say that sometimes justice is there for something, okay. Now we have to work on pressing the Commission to do something about that. Okay, I want to thank you, Ignacio and Tiziana, for this event, and all of you. And yeah, I would like to start just naming some trade agreements that are currently being discussed or reviewed by the Commission. We have Mexico, Myanmar, Japan, Mercosur, Tunisia, Philippines, Indonesia, TISA, maybe TTIP, and China on investment provisions. And there are some others that are recently been established. We know like CETA, Vietnam, South Africa, and other in different negotiation phases like Australia, New Zealand, the Andean Community, Chile, or Turkey. I could be on and on saying names, but my goal is not boring you to death. So what I want to outline with that is the never-ending dynamic of an international trade model which is leading us to a scenario in which states compete with other states, like Coca-Cola competes with Pepsi. As Bill Clinton described it during his mandate, he told, "Every nation is like a big corporation in the global market." This competitiveness rhetoric turns citizens not into workers, but into pieces of a machinery whose only goal is not the well-being of the people, but just corporate benefit. And this obsession with competitiveness is not only wrong, but is very dangerous. They lead to damaging and immoral economic policies while alienating national and international policy because it complies all the way from domestic healthcare, for example, to foreign trade policy. We cannot, of course, compare a state with a private company. If a company is not competing well within its market, it can close, it can liquidate its goods, it can liquidate its capital, and be one for the record books. However, a state cannot just shut down, it cannot close. That's why this leads us to an endless logic, to this dangerous competitive spiral to the bottom, and understanding countries' development as an employing state. This is the logic with that the European Union is working now, and if he's drafting with this logic the principles of its trade and development policy that is very dangerous. It's not trade, is that this trade logic is also in the development policy of the Commission. They only look for bigger and more open markets for our multinationals. This is the only aim. Beyond theory and many social movements which they are pointing, as usual, the way forward, we must find cracks in the institutions to put our foot in the door before it's closed, and subdue those who always are reluctant to make some changes to shape the globalization in the aim of the human rights and the well-being of the people, and stop these paternalistic, extractivist and choppy policies towards developing countries. Before mentioning the progress that we achieved in the Parliament with the garment sector report, I would like to recall and support some interesting processes that are going on now, and I think that the most important that we have to spread and let people know, because media are not doing that, is the United Nations Working Group on Corporation and Human Rights. It's also known as the Binding Treaty process, but as long as we see till now, European Union is reluctant, very reluctant, and even in the first meeting, the representative of the European Commission tried to block this process. So we also know that the member states are not on the line of supporting this process, but this process is already open, it's working. In October we will have the first draft text of the treaty, so it's our responsibility to support this process and to push member states and Commission to do what they have to do, because they are tied by our laws and by our values, of course. But okay, I don't want to repeat what Tatiana said about the conflict minerals, that it's quite important, but not the real mandate of this Parliament, but it's a good step forward. But we have other examples, for example, on palm oil, that is very recent, on rainforests, on global value chains, that it's already under work, and now it came the turn for the garment sector. Sorry. You know that in 2013, Rana Plaza factory collapsed, and it was one of the biggest industrial crimes in history, with more than 1,200 killed. So we need laws to stop the corporate impunity, because in our globalized economy, the garment sector in particular have been evident this impunity for a very long time. There has been public campaigns to do so, like a Clean Clothes campaign, or recently Who Made My Clothes, but voluntary initiatives are not enough. After Rana Plaza disaster, there was a turning point, and one of the steps that the Commission made 2 years later, we are talking about 2015, Commission announced the release of a flagship initiative on the garment sector. Okay, but 2 years later, today, 2017, Commission has done nothing on that. After calling this flagship initiative, he's done nothing. So in the Development Committee, we decided to undertake this own initiative report. And our position was clear from the beginning, that we need a legislative proposal. We are asking the Commission for a legislative proposal. We are asking for binding due diligence obligations, and we are asking for transparency obligations in all the value chains from the beginning till the end. At the beginning, of course, some political groups rejected even the very basic demand that was asking for a legislative proposal. So it was our first battle to convince some political groups that the Commission should release a legislative proposal, because they seem it seems that they are very happy with the voluntary initiatives. But we could build up a strong alliance of progressive political groups in the Development Committee, and it was a key to set a negotiation that started very difficult. We achieved moving EPP from voting against this report in the Development Committee to finally they voted abstention. So the report went to the plenary, and NGOs played a very, very important, a key role in all this process. First of all, we opened the draft text to them, so because they are the ones that they best know in the field what's going on, how these corporations are doing things in countries very far away that we don't see in the media, in television, and which are the human rights abuses that they are facing. And secondly, because their pressure was key during the negotiations. And it's going to be key now that comes the next step, that is putting pressure on the Commission so they can deliver a legislative proposal. Okay. So finally, we could put in the report these main points. Voluntary initiatives are okay, but they are not enough at all. They are not working. We need a European framework. We need also protection for European companies, because we have to remember that 30% of the clothes in the European market are made within the European Union under our laws. So this is a very important social dumping, labor dumping that our international companies are making to our national companies. International European companies, I mean, and that we need due diligence obligation. And this work, the best part of that is that the Commission doesn't have to make any work, because it's done already. OECD launched some months ago their guidelines for due diligence within the garment and footwear sector. So this is a very extraordinary starting point, because Commission doesn't have now to find out how to do that. It's already done, it's on the paper. It was made with the help of the companies. So now the ball is on the Commission's roof. We demand clear and binding legislation on due diligence through the whole supply chain. And in the context of this widespread and recurrent debate within institutional and corporate spheres, I would like to conclude with a reflection. Our democratic societies rest over a social contract, a universal and inalienable contract by which we organize and regulate relationships among peers. Willingness is legitimate, applicable when it comes to choosing our friends, but it doesn't work when it comes to human rights and human dignity. It's not a voluntary to respect human rights. It should not be, it cannot be. It cannot be like that. So this is the reason why the base of our current contract, not only with our citizens, but with these people that is working for us, is working, producing, sowing, mining, or fishing, and outside our borders, needs to be revised. Thank you so much.
Grazie Lola.
Thank you, Lola. And we bid farewell to our colleague who's just left. Thank you very much, Lola, for your presentation. I think later we may have some questions, but I would just point out that when it comes to human rights, these are sacrosanct. Even when we're talking about economic issues, there are a lot of companies where it's cheaper for them to produce in or to do their manufacturing in low-cost areas, and this is advantageous to consumers in one way, but on the other hand there are serious implications for our own companies who lose out, and our internal demand shrinks because of this. So as well as the human rights issue, which is sacrosanct, there are also key economic issues to be borne in mind. There are negative economic returns for us as a result of this. I'd now like to give the floor to Klaus Buchner.
Speak in English, or you usually speak in German, but we have no German translation. So thank you for your contribution. Klaus lavora con noi in molte commissioni.
Klaus is working with us in the Foreign Affairs Committee and others, including Inter.
Sta occupando di un file molto importante che è quello sui.
He deals with dual-use goods, a very important issue. You have the floor.
Thank you very much. We are talking now about dual-use regulation. As the name indicates, this regulation restricts the export of goods which can be used both for normal commercial applications as well as for the construction of weapons of mass destruction. Now, the reason for the recast is that we want to include also surveillance technology. This was necessary because in the Arab Spring, European technology was used to pinpoint and arrest people of the opposition. And these people were tortured, quite often killed, so we definitely have to stop this. And the European Parliament has asked the Commission 15 times to start the legislation in this direction, 15 times. And only now the Commission has reacted and has proposed a regulation which well, has many difficulties because the field is new, completely new. As far as I know, no such regulation has been made ever before. There are many problems. For example, to define human rights, due diligence, surveillance in such a way that the industry can work with it, that you can make court cases for violations of the behavior. So that is one difficulty, and we get a very strong opposition, of course, because it's a market of 80 billion euros per year. So you can imagine the industry is interested to have, let's say, something favorable for them. My idea as a rapporteur of this regulation is to follow the example of the torture goods regulation and the conflict minerals regulations and make the export of dual use conditional on the preservation of human rights. Well, that was the basic idea of it. No European exporter, especially in the area of cyber surveillance, must be legally able to export products that facilitate the violation of human rights, as it was the case some years ago, and as it is still the case in many countries, let it be Qatar, Bahrain, Syria, or in many other countries. I'm sorry to say also Italian companies have become unfortunate examples of exports I am working to stop. Milan-based hacking team is one of the a prominent example, selling surveillance technology to highly repressive governments. More recent examples are Italian surveillance giants ARIA and IPS, who have been shown to easily circumvent the current regulation and are willing to sell highly dangerous surveillance technology to repressive regimes. And here it's a real problem, because not only these firms have done this, also many other European firms, I am just mentioning them now. There are easy ways to circumvent such a regulation. For example, we try to control the selling to a specific country or to a specific end user. What people do is very easy. They sell it to somebody else, and he resells it to a dangerous person or a dangerous government. So we have a lot of technical problems in these regulations which probably cannot be solved completely. We try our best. So I propose to include a human rights-centered mechanism that allows export authorities and governments to stop these circumventions. We will try, but against a strong opposition from industry. I further propose to take a European lead on the global arrangements, namely Wassenaar, who tried already to regulate such things, but it was not sufficient, as the examples I was mentioning show, because they are lagging massively behind with the technical developments. You must imagine these international bodies have to achieve some agreement between all the member states, and that takes years. And the development of just this technology is very fast, so they are always behind. And that is one big problem which is under discussion now, the so-called catch-all clause. We try to include a clause which allows ad hoc a member state, or probably also the Commission, to introduce a regulation on completely new technologies, which we cannot foresee now with this regulation. And of course, you can imagine many people and many political groups don't like this. But on my side, I have an advantage. Such a clause is already has been working for more than 25 years in some European countries. And the tendency is to stop this. We try our best, and we will fight for the human rights, and I hope we will succeed. Thank you.
Thank you very much, Klaus. Ok, adesso proviamo a...
Right, now we'll try and link up with Professor Alberto Arufat from Valencia University. Hi, Alberto.
Lola, questa volta sei tu.
Lola, you've got the advantage now because Alberto's going to speak Spanish.
La interpretación, Alberto, pues que vas a hacer tu intervención en español y después yo intentaré hacer uno.
I will try and produce an interpretation of what you've said after you've spoken because we don't have interpretation from Spanish this afternoon.
Lo siento por ese problema que tenemos con la interpretación, ¿vale? Porque era un problema técnico con lo de traducir desde Skype.
Ok, bueno, no pasa nada. Trato de explicarme rápido y, bueno, si haces la traducción no creo que haya problema.
¿Tiene la palabra?
You have the floor. Interpretation can be provided after all, as long as the sound is good enough. So, honourable members, thank you very much for your invitation and this opportunity to talk to you this afternoon. I'd like to develop the idea of a particular European label relating to human rights obligations being complied with outside the EU, and I'd like to look at the advantages of this abuse-free label and talk about how it will be implemented.
De los estados, así como
Alberto, disculpe. Bueno.
Interpretation will be provided from Spanish, so no worries. You can carry on speaking. It will be provided as long as the sound is good enough. It isn't terribly good, actually. So, the system, the continent has benefited from a human rights protection system which is a global reference. There has been a commitment to the most advanced system of human rights in the EU, and the EU has ratified various human rights treaties demanding that those who fail to comply with human rights regulation, whether legal or natural persons, should comply. Now, I come from an area with very high unemployment, but if you look at our human rights situation, they're very good compared to the rest of the world, and the EU is a bulwark in the area of human rights. It needs to continue to work. Since its very outset, and particularly since the Lisbon Treaty, the EU has promoted the expansion of human rights through its trade policy and agreements, and the EU has done a lot of work. But when it comes to mechanisms for implementation, that is key for European players acting outside their borders. Citizens and businesses working abroad also need to be committed by these values, so the EU can play a very important role providing a simple and secure mechanism. The EU and its businesses are sometimes accused of human rights infringements, and we see social dumping going on in order to achieve greater competitiveness. I'm afraid the sound is breaking up and it's very difficult to interpret.
Perjudicar los intereses europeos. Por otro lado, algunas empresas han explicado sus problemas para aplicar las normas de derechos humanos, alegando que estas reglas son confusas y dependen del contexto de cada caso. A continuación me gustaría señalar ventajas que la post-free label supondría, ¿no? En primer lugar, querría decir que, bueno,
I'm afraid the sound keeps breaking up and it's virtually impossible to interpret from this.
Europeas contribuiría en primer lugar a crear un mundo mejor, donde los derechos humanos fuesen más y mejor respetados y por tanto promoverían un mejor cumplimiento del derecho internacional y de los objetivos de la Unión Europea. En segundo lugar, facilitaría a las empresas una garantía y un instrumento de defensa a posibles denuncias justificadas y también mejoraría su expansión, dado que le permitiría encontrar socios locales con una mayor facilidad, rompiendo las resistencias e intereses particulares existentes en algunos mercados exteriores. En tercer lugar, favorecería un mejor cumplimiento de los objetivos de la Unión Europea establecidos en los tratados, dado que ahondaría en la identificación
also enable better achievement of the EU's objectives
exterior en un momento donde ha perdido peso
and improve the EU's image at a time when it's lost its clout internationally. And maintain a clear focus and increase the EU's negotiation capacity when it comes to free trade agreement. Finally, internally, this might do something to combat Euroscepticism and anti-European feeling. It would help the EU connect with European citizens, particularly those who are most committed to these issues.
La cuestión, a continuación me gustaría distinguir las ventajas que
the sound is cutting out quite terribly, so we can't, for the time being, interpret.
En ese sentido, la cuestión de la relación entre las empresas transnacionales y los derechos humanos es compleja.
Alberto, disculpe.
Sí.
Creo que tenemos...
Alberto, I think we've got a problem with the sound. If you could speak a bit closer to the mic, that might help.
Porque si no le sale un poquito difícil a
Because otherwise it's really impossible for the interpreters to hear properly. Don't worry, but just move a bit closer to the mic, if you would.
Que voy ahora a explicar las diferencias y ventajas.
I'll try and explain the pros and cons of this compared to other instruments. When it comes to the link between European companies and human rights, this can be quite tricky. The UN acknowledges companies' ability to improve living standards within a short period of time, but there's no indicator providing verified data on the damage caused by corporations to human rights across the world, even though more and more individual cases are becoming known. The international community has made proposals to obviate or mitigate the negative effects. Quite a lot of work has been done in this area. For example, the proposed code of conduct for companies, and the Secretary General of the UN establishes the Global Compact. This goes back to 2005, and in 2011 the guiding principles on enterprises and human rights were adopted, and this was a US initiative. The EU has done a great deal, particularly in the policy and legislative framework, and articles on criminal responsibility of legal persons have been included as well. And we shouldn't forget about ISO standards and CSR. Now, all these initiatives have had specific success, but actual improvements have been rather thin on the ground. And it would appear that there are some difficulties and shortcomings which make it difficult for these to become actually effective. In some cases, there's a lack of institutional support. In other circumstances, global agreements have been built on the lowest common denominator, and they're quite lax. And then there's the issue of incentives as well. So the abuse-free label should be part of an international and European movement to get companies to respect human rights using existing instruments, using an innovative methodology, and finding an innovative way of overcoming obstacles. And then on the abuse-free label itself, this would identify companies which have implemented a generally defined process to ensure compliance with human rights, and it would look at where they are investing and producing their products. The label would just look at human rights issues, and it would be complementary with other fields such as compliance with tax provisions, and this would concern companies with their headquarters in the EU and which market their products in the EU. The label would go to the company, not the products, and the aim of the procedure would be to boost continued thinking and to promote human rights across the borders. And there would be indicators set up. The general procedure should be set up by human rights experts, business experts, and auditors. And the procedure to get the label would have to be designed by the large, medium-sized and small players, and there'll be different stages before a company got the label. There'll be an initial stage where an independent body authorized by the EU would set out the mechanism for giving the label, and there'll be a unit set up in the company to ensure that everything was properly documented, and then there would be monitoring by a panel of experts. An independent expert would be authorized to draft periodic evaluation reports and proposals for improvement. And then finally there'll be a third stage where the label would be granted on the basis of a report, and there might be specific measures imposed. The label could be granted for a specific period with reviews, and we'd get further information on the company's website, and the requirements would gradually increase. Getting the label would be a voluntary process. It would be difficult to demand it by law, but the abuse-free label would be promoted by the EU through legislative measures, which might include the promotion of campaigns so that consumers can recognize the label. It could be mentioned on EU websites, and it could be considered in tendering for European contracts as well. And the EAS could promote greater awareness raising outside the borders of the EU. So I think that's it.
Bien, está muy bien.
Fine and dandy, Alberto. Thank you for your contribution. My pleasure.
Corriendo para decir muchas cosas, ¿se entiende?
You had to fit a lot into a short space of time, didn't you? Never mind. Obviously, the issue of new tools which could be tapped into to try and regulate for and improve levels of trade, the rules of trade, and the obviation of inequalities which have arisen throughout the years. So that's been put into the UN guiding principles, and we've also slotted this into a report signed off on initially in the Human Rights Committee, and then there was a broad majority behind it in the EP plenary. And this follows up on what we were talking about before on the shift in trend and the greater awareness we have now, as Tiziana rightly said when she mentioned the fact that when we talk about human rights, we're not talking about something which does not have economic effects. This is of interest to European companies. Inequalities which have arisen by dint of these treaties has been tapped into by rampant globalization and neo-capitalism, whose proponents think they can govern everything. This has led to tremendous fallout for all stakeholders. Just as in our own countries, we have producers of citrus fruit who complain since they are being flooded with products from elsewhere in the world and are sold at half price. And the same happens with artisans, paddy field owners from the north of Italy. We've heard also about the garment sector suffering. Lots of families got by producing garments in the EU, but it's no longer possible due to delocalization of production and the lower cost of foreign products. So we need to think about new clauses and mandatory binding tools, binding mind on traceability of the production chain. More awareness of consumers is also needed. More often than not, we think about what's best for the market, and by dint of this logic, the multinationals lay down the law to us. The market takes it for granted that we citizens who have grown up within the EU, well, we consumers take it for granted that in our local supermarket we have products available from the other hemisphere of the world at half price. We don't know where the products have come from, how they were produced, whether the workers who took part in the process were working under conditions of slavery, whether there was exploitation of child labour, whether these products were manufactured in areas of conflict, whether there were infringements of any kind of rights. So our entire market within the EU is based on this supposition. We hear, of course, complaints from our manufacturers who are no longer able to compete on an equal footing, but we should not shoot ourselves in the foot here by thinking that locations elsewhere in the world are gaining advantage from this. That's not the case. Often in South America, in Africa, in developing areas in the southeast of Asia, in any other part of the planet, where agreements have been struck with the EU and with EU multinationals, more often than not, the local populace are having to accept sales conditions dictated by the very multinationals. So we need to be mindful of the fact that we need to think about where the cheapest production cost is, and this of course entails exploitation of the labour force, minimum taxation and so forth, and there is a complete lack of compliance checks elsewhere in the world, which means there are no guarantees in place to guarantee the health of our consumers, since checks are skirted elsewhere. we have a situation which is all but fair. The major flag wavers for the European market, the major Europeanists, those who are in favour of private free enterprise, well, maybe they're all eating their words, because they must surely have realised what damage is being inflicted on the EU. I've said my 2 cents, so back to Tiziana. We'll open up the third panel. Thank you, Ignazio. Now, we've rounded off the section on trade agreements and general trade. We are keeping a kind eye on trade which respects fairness and equality. We also have a trade system in place which is very stringent about compliance with the rules. Plainly, we need to keep close tabs on who is gaining from the opening up of our markets, and we need to appreciate what the negative consequences are of globalization to avoid unfair trade. Some foreign countries engage in unfair competitions, social dumping and so on, and they sell their products below the level of the price in their market. The idea being to push competitors out of the European market. There are other examples of unfair competition elsewhere. For example, non-compliance with geographical indications of origin. There are many examples of unfair competition out there, and I'm sure this could be a serious problem by way of compliance with the treaties. Our stance has always been very plain on this. The situation has worsened. We had the market economy status awarded to China. How was this feasible, given the protocols for access under the WTO? So I'd like to give the floor in a virtual fashion to our rapporteur, David Borelli, who was the first to grapple with this issue. He's sent us a video because he's presently not on the premises. He has commitments elsewhere. Davide was one of the first MEPs to actively deal with market economy status for China. He was a member of an MEP's pressure group who wanted to stand up for those sectors suffering thanks to Chinese imports. He's acted very vigorously and in a determined fashion, and he's achieved very satisfactory results. He's the shadow rapporteur for our group on trade defence, so the floor goes to him.
Ci fanno partire il video.
Roll the film. Good afternoon, everybody. Thank you for having invited me to this meeting. I'm David Borelli. I'm a member of the European Parliament for M5S. We're talking about the market economy status for China, abbreviated to MES. When mention is made of this issue, we have, of course, to refer to dumping. What is dumping? Dumping is a trade practice, a trade strategy, which is normally set up by one country to fight against the market of a foreign country. What does this really imply? Well, I'll give you some simple examples. Let's say that manufacturing this phone in Italy costs 100 euros, and that the production cost is different in China. China could decide to export towards the Italian market, and this phone could be sold at 80 euros. Now, you don't need to be an economic eagle to understand that this practice cannot be sustained by a company. If I produce at a higher cost compared to the sales cost, inevitably my company will go under. This will mean state intervention, which will soak up the company's losses. To pay its debts to ensure that this kind of operation cannot happen. So the foreign market will be flooded by dint of unfair competition until this market is saturated. There is complete possession of the market, and the local market is destroyed, and there is a monopoly. Clearly, this operation has been conducted many times by China, so the Italian economy is particularly stricken because we are very much a nation of producers, and dumping operations tend to be conducted with products which are assembled in Italy. For example, bikes, ceramics, paper, steel. There are a great many sectors which in the past have been struck by these unfair trade practices, and these operations could recur in the future. Awarding MES, market economy status, to China does mean that we have no tools to stand up for ourselves against these kinds of operations. The film has stopped.
E quindi di status di economia di mercato.
So market economy status for China. This is a topic for debate in the European Parliament and has been so for about 18 months. The media have kept stum about this. There has been very little publicity about this. This topic was debated in the EP, and last year there was a risk of this being signed off on by Parliament. What did we manage to do? Well, we pooled our efforts. We stood shoulder to shoulder as Italian MEPs. And we also brought on board MEPs from other countries. So we set up a group of 90 MEPs who worked together to conduct a public consultation. We called upon citizens to give us their views on this, and then we tabled the results in Parliament to try and win round our colleagues to say, look, if we give China MES, we will be slitting our own throats and that of the European economy. So we reached out to citizens, to students. We contacted representatives of the various economic sectors. We consulted companies, and the results were plain. 97% of people who responded to this survey, and almost 8,000 parties responded. 97% said that MES should not be awarded to China. And this went into an official document last May during the EP plenary in Strasbourg. The EP struck a clear stance, saying to the Commission, look, the Parliament is against this status being awarded. The Commission is trying its luck again, so this is going to be a hot potato again this year. The Commission is trying once more to table the awarding of MES by changing the terminology used in order to misrepresent the situation. They're no longer talking about awarding market economy status. They've introduced the concept of significant distortion in the market. Will it be possible to defend ourselves from dumping? Only if this situation is picked upon. And there's the question of burden of proof. In other words, proving whether dumping has taken place or not. The burden of proof is on Europe, whereas previously it was the foreign producer, in this instance China. So this kind of situation is a slippery slope, because there is no case law for this type of terminology. So it'll be very tricky to effectively prove that there has been a significant distortion of the market. We have severe misgivings here. The words may sound pretty, but we may be standing here above a trap door. China and other countries may be tempted to slip through the loophole we have left open so that they can invade their industry using unfair competition. So let's wage this battle once again. We will take to the trenches once more. We will continue to gather information and disseminate it. We'll call a spade a spade. We'll tell citizens precisely what's going on. We'll explain the Commission's new stats. We'll try and reforge the alliances we forged last year in the Parliament, so that once again the Parliament will reverse the tack taken by the European Commission. And I will leave the floor to the other members of the panel. Some of them will deal with more technical issues, explaining the precise details of the proposal currently being floated by the Commission. Thank you one and all for allowing me to speak, and warm thanks to you all.
Grazie virtuale a David.
Well, virtual thanks to Davide, and real thanks for all the work he's doing in this very important issue for our Italian companies. And now we're going to give the floor to Ines van Leerd, who previously was a European Commission official, but now she chairs Aegis Europe, a European federation bringing together companies who work in various areas, iron, ceramics, a whole range. So they have already been hard hit by Chinese competition, and it's likely that there'll be a further blow if Europe doesn't take action. Over to you.
Thank you very much for inviting me today. Yes, indeed, I worked 6 years in the anti-dumping service of the Commission, which gives me a little bit, let's say, the inside view of those proceedings. So, as it was just said by Paola, I think, in fact, I have two hats. I'm representing a European federation. I'm the Secretary General of that federation on the one hand, and on the other hand, I'm also the chair of Aegis Europe. And today, we just agreed with Laurent that I would give you, let's say, my practical experience within my sector, and that will maybe explain or justify why I am so committed and so concerned by these trade defense issues. So what is my sector? My sector is in fact a small sector but very strategic. So we represent ferroalloys producers, silicon producers, so that these are basically commodities. Ferroalloys are used in fact by one customer, and this is not a small customer, it's the steel industry. And silicon, there are, let's say, more applications. There are applications in the metallurgical sector as an alloying element with aluminum, for instance. In the chemical sector as silicone, raw material for silicon, but more recently as well, and you just referred to it, as a raw material in the solar panel value chain. And so, I say it's a small sector. In fact, all my members all together represent 21 companies. And we have lost our national federations because there weren't enough companies left per country. And I have to say that maybe the saddest example of that situation is in Italy, precisely. In the early 90s, there were 14 producers, ferroalloys producers in the north of Italy. And today there is just one company left, and this company is really struggling to remain on stream. So 13 companies had to shut down, always for the same reasons. So sometimes I'm asked by people, but in the end, what kind of difference does that make, whether there are anti-dumping measures or anti-subsidy measures? Is there an issue of profitability or investments? What is really the benefit of those measures? And in fact, my answer is very straightforward. The fact that we have been so active in trade defense for, should I say, 30 years, has made a big difference, that still today there is still a ferroalloy and a silicon production in the EU, while without those measures, this industry would have just been gone, disappeared, no production. And so I wanted to share with you a couple of practical examples of that practice. And these are cases where I was personally involved in as complainant, so representing the interest of the producers. One example is magnesium. I think you have all heard about magnesium. And there was a very competitive production in France. It was a former Péchinet group. The plant was called the Marignac plant. And in fact, this plant faced an untenable competition from China. And we tried everything. So there were anti-dumping duties. Those duties were absorbed. They were circumvented. So it was just not tenable. And what happened is that after 2 or 3 years of hard fighting, in the end, the company had shut down. So, and what has happened since then? But since then, it's very clear. You can check that in the statistics. In fact, the EU became 100% dependent from imports from China. China has a dominant position on the magnesium market, and not surprisingly at all, these prices have gone up. So when people say, but we have to think about users and consumers, I think it's a wrong argument, because at least for industrial interests, users are not at all advanced. There is no advantage for users if there is no domestic production left in the EU, and magnesium is as an example. Another example I wanted to share with you, because that will lead me to some comments that Laurent, more technical comments that Laurent will make afterwards. It's a case regarding ferromolybdenum production. There is production in Belgium, in UK, in the Netherlands. And so this was a very atypical case. It was against China, of course. And the main producer of ferromolybdenum in China, under the current methodology, said, I want to be treated as a market economy company. I want to have this individual anti-dumping duty. And you know that this is possible according to the rules. And so the company replied to the questionnaire, nice questionnaire within the time limits, nice figures, everything looked perfect. The result was that at the provisional stage of the investigation, the company got a 2.5% anti-dumping duty, which is nothing. We are so close to zero, in fact. And after provisionals were imposed, in fact, by coincidence, I got the information through the website, by the way, that in fact everything had been organized in China to ensure, so with the help of the national authorities, local authorities, to ensure that all ferromolybdenum exports from China would be challenged through that company, because of course the duty was much, much lower. But when you know that to be eligible to meet really the conditions for getting this market economy treatment, that means basically that you have no link, that there is no link between the company, or no state interference within the company. This was really extremely shocking. So I went back to the Commission and I said, come on, this company doesn't deserve at all the market, the duty that was imposed. And in fact, the Commission went back on spot. So after provisional measures, so they went back, they investigated the company again, and and the Chinese company didn't expect that at all. And so this is when the Commission found that all the questionnaire was faked, that there was a double accounting system, and that, of course, the duty was completely biased. And so the final duties were, I think, around 20% instead of 2.5. That gives you a very clear example of what could be the difference in the level of duties should a company, a sector, an industry be treated as a non-market economy industry sector or company and a market economy one. The last couple of examples I would like to share with you, also very practical. Silicon, as I said, it's the raw material of the solar panel value chain. Silicon, we are all aware of the problem of excess of capacities for steel, but in fact, I would say maybe all members within Aegis Europe face the same problem. And the silicon industry is another terrible example of that fact. For instance, according to our estimates, because it's never sure in China, but there are silicon capacities in China which are able to meet twice not the EU consumption, the worldwide consumption, so twice the worldwide consumption. And so this is going on for ages. So another comment and last comment I would like to make, another example, ferrosilicon, which is really a basic ferroalloy which is used by the steel industry. Again, the main producer of ferrosilicon in China, which is a company named Erdos can on its own, and there are hundreds of ferrosilicon producers in China. So that company on its own can meet the EU consumption very easily. And by coincidence again, it is that company which got market economy treatment, so an individual duty of 15% instead of the overall duty, which is 30%. So these are very practical examples that I wanted to share with you, because that shows you how important it is to have strong trade defense instruments, because China is able to play games, is, in my opinion, not reliable, can go that far to bias information, and this is why we have to be very, very strong on the methodology, on the level of evidence which will be demanded, and that the burden of proof be on them and not on us. So this is what I wanted to say, but I would be happy to take questions afterwards. Thank you.
Grazie.
Thank you very much indeed, Ines. And I think something we'd like to stress is that we've seen from the examples how some sectors are overrun with imports from China, real dependence on China, particularly in the magnesium sector, for example, and we see the effects on workers whose plants have closed. That's a real effect. So if you think that the MES issue is limited to a certain group of companies, that's not the case. There are an awful lot of companies affected by this, and a loss of jobs in a particular sector at a time like this, when there is low growth and our continent has reached a certain level of growth and is standing a bit still, it's very difficult for people who've lost their jobs to find another job, and they stop being consumers. They stop going out to eat and things like that. And this has considerable economic effects in the short and medium term, which are absolutely disastrous. So this is something which really affects us all, not just those directly exposed to competition from China. Now I'd like to give the floor to Mr. Roisman, who is a lawyer who is specialized in anti-dumping issues in international trade. Over to you, sir.
And good afternoon, everyone. Before starting a presentation on the more technical aspects of what's being proposed by the Commission and now the Council is accepting as a compromise, I would just like to follow on Ines's comment about the ferrosilicon industry and how you had one Chinese producer able to produce enough for the entire EU market. Actually, we have another example of that, which is very striking, which is in the bicycle sector. Now, you may not realize this, but in Europe, we consume 20 million bicycles a year. Well, it so happens in China, they produce well over 80 million bicycles a year, and they only consume themselves about 25 million. So they have a large surplus production. But there's one Chinese producer in particular, the major producer, who has just set up a new factory, just opened, which produces by itself 20 million bicycles. So you've got the same situation there, huge overcapacities, and yes, we know which market they are looking to, because they've already taken over, in the case of bicycles, they've already taken over the US market, and the EU market is the only large market they have not yet taken over. The other thing to mention quickly is that anti-dumping duties are extremely important. So what we're talking about here is primarily anti-dumping duties. There's one small revision in the Commission proposal that deals with anti-subsidy measures, but we're talking primarily about anti-dumping measures. And it's extremely important that we have effective anti-dumping measures, because in anti-subsidy cases, we end up with very low levels of duties. It's very difficult for the Commission to find out all of the subsidies that companies are getting, especially when there's no cooperation from the other government who's giving out these subsidies. And this has been, unfortunately, the case with China. So, having said that, I want to speak in particular about the legislative proposal which is on the table and which the Council is going to adopt a position on tomorrow. So, essentially what the Council is doing is it's accepting the Commission's starting points, and I would describe the starting point of the Commission as having three elements. First is that the European anti-dumping legislation must change. But then if you ask the question why, it's not so clear. So there's talk about a provision of this protocol which expires, but nobody actually has said, at least that I've heard publicly, what that means, or from the Commission side. And now that's also true from the China side. One of the things that's been said by Commission officials is, well, we are vulnerable because our legislation names China and says that we have to treat them as a non-market economy, and then all the consequences that flow from that. But if that's what the problem was, then the proposal goes much, much further than that. And so there seems to be something else behind this, but it hasn't been clearly stated. A second element, which is, I would say, a starting point for the Commission proposal, which the Council is accepting, is that the EU should no longer apply a special regime to certain other WTO members, a special regime for non-market economy countries. Why are we walking away from a special regime which has been applied to non-market economy countries for decades? This started long before China joined the WTO, and there's nothing in the protocol that deals with whether or not countries can have, or regions can have, such a regime. And so again, it really calls out for a coherent interpretation of what happened last December. The third element the Commission is starting from, and which the Council seems to be accepting to a large extent, is that in order to be able to cover every situation, so this new methodology will apply to all WTO members, the new methodology must leave plenty of discretion to the Commission in practice. But what about legal certainty? Companies, industries need legal certainty in order to make investments. The last thing industry needs is a legislation which is very vague and which they don't know from one day to the next how it will be applied in a given case. What about European Court review? The European Court, when it's faced with very vague legislation and a very concrete issue before it, is forced to adopt an interpretation of the legislation one way or the other. So basically, the Commission's proposal takes no certain position as to whether we're dealing with a real non-market economy methodology or a simple cost adjustment methodology. And it essentially means that it's going to be leaving it up to the European courts to fill in the blank. This is not ideal for European industry. In the end, the big question is, what is the difference between this proposal, even as the Council has revised it, and the granting of market economy status to China? As David Borelli alluded to, in fact, you could say it essentially amounts to the same thing. It's very striking if you go back and look at the three options the Commission presented early last year. Option 3 was we give China market economy status, but we also adopt some mitigating measures. Well, one of the mitigating measures, the top one, was we strengthen our regime to deal with cost, to make cost adjustments. And if you look at this proposal in that light, it looks exactly like option 3. It's just that we don't talk about giving China market economy status. But we have a regime where we treat China, we will treat China if this is adopted, just like every other WTO member. What's the difference between that and granting market economy status? Okay, so actually David Borelli went over the changes proposed by the Commission. I'd say there are 4 key elements here. First is the removal entirely of the distinction between market economies and non-market economies in favor of a new methodology, a new regime, significant distortions, which is untested and for which there's no clear legal basis. The new methodology would make use of undistorted third country prices or international benchmarks for various factors of production. So we're going to go through cost by cost for each product in a given investigation. But then the question is, do we automatically do that for every factor of production, as we would with a non-market economy methodology, or only those for which we can positively demonstrate that there are distortions? And that's the standard cost adjustment methodology. So there's a real ambiguity here in the proposal. It doesn't make clear. It is clear that the burden of proof is on the Commission, and that's a significant departure from the current regime. But it said the Commission will issue reports which will be collections of evidence of significant distortions, and the EU industry can rely on them in filing a complaint. But if you look at the language of the proposal, and here the Council compromise doesn't really help, you don't have certainty as European industry. It says the industry can rely on the reports, but it doesn't guarantee you that these reports will be considered sufficient evidence in any particular case. And this leads me to the specific modifications made by the Council. In fact, there's essentially one main modification that they've made to each of the 4 subparagraphs in the proposal. And I just addressed the one about the use of the Commission reports. But starting from the beginning, the question of the burden of proof. The Council has approved the insertion of a paragraph which will essentially say that the Commission, when it determines that certain domestic costs are undistorted, in particular, where the domestic producers can show this conclusively, it will use those costs. But this is very interesting. So the Commission makes a determination that domestic costs are undistorted, but there's no burden of proof on the domestic producers to show that those costs are undistorted. It says, in particular, where exporters and producers show this conclusively. That means, in particular, that means this is one example, but it's not the only case where the Commission would use domestic costs. So this provision inserted by the Council is actually not all that helpful. I mean, it's a step in the right direction in that the Commission proposal didn't address this issue at all, but it's not enough. A second change made by the Council is to add into the list of criteria to be considered for determining whether or not there are significant distortions, essentially a summary of the market economy criteria. Again, this is helpful. One could question whether it's sufficient. I mean, we still don't have any labeling of these as market economy criteria. We still don't have the distinction between non-market economies and market economies in the law, but at least it's a change going in the right direction. The Council compromise also clarifies when reports shall be produced. That language, I would suggest, is somewhat helpful. But it doesn't clarify the issue of input from parties. The current language of the Commission proposal, which the Council has accepted, gives the impression that basically anyone can put in evidence on the file that could call into question the value of a report. And this completely undermines any legal certainty, because it essentially means that throughout an investigation, industry has no certainty that in the end the Commission will actually be applying this new methodology. Because in the end, depending on what happens during the investigation, you could end up in a situation where it just applies the standard methodology. So again, no legal certainty here. What about the draft report by the rapporteur of the INTA committee, Mr. Chiku? That draft report makes very helpful clarifications. We would suggest that we can go further. I'm happy to go into the details on that, but I'm not sure I have time, because I would like to touch on a couple of other points, but if anyone would like to discuss that further, we can. But at least the Chico report does give us helpful clarifications about the methodology, that it should be for every factor of production, and the burden of proof should be clearly on exporting country producers. And it does have additional provisions about the Commission reports and about the ability of the EU industry to rely on those reports. So these are very helpful amendments, and we hope that in the Parliament we can go even further with that. The two other aspects I'd like to touch on just very briefly. One is the alignment with major trading partners. And the reason for focusing on this, well, there are a couple of reasons. One is because the Parliament itself last May specifically asked the Commission to make sure that whatever is proposed is aligned with what's being done by our major trading partners. Well, this actually isn't addressed in the legislation itself, but what you can say from looking at the proposal and what the Council is doing with it is that it is actually not aligned with our major trading partner, the United States, and for that reason I would say others as well. In fact, no one other than the EU is moving towards changing their legislation as a result of the change last December. The US in particular continues to have and to apply a distinction between market economies and non-market economies. It continues to apply a methodology which is a non-standard methodology, which only uses domestic costs and prices in China if the local producers demonstrate that those are market prices. And right now, the US has opened an inquiry into China's market economy status in the context of the first investigation it opened after December 11th of last year. And why is this significant? Actually, it's not because the United States is thinking of granting China market economy status. It's basically to update a report that the United States did in 2006 to say that China doesn't meet the US's market economy criteria. And this way of acting is entirely in line with the US interpretation of what that expiry of that one small provision meant last December. Something the US has just made explicit over the last few weeks, but the EU still hasn't done itself. And that interpretation is essentially to say, before December 11th, other WTO members could automatically treat China as a non-market economy, but after December 11th, you have to do it on the basis of a factual determination. In other words, you need a report. You need to evaluate Chinese economy according to your market economy criteria. And if you think about it, it makes sense, because in 2001, when China joined the WTO, no country, no WTO member had a report on China. Nobody had done a determination to say, yes, China doesn't meet our criteria. Everyone applied a non-market economy treatment to China simply based on the protocol. So the situation that's changed is now the U.S. is saying we can no longer do that because of the expiration of this one subparagraph. So now they are doing an up-to-date factual determination. It's interesting to think about what are the implications of that line of interpretation for the EU and what that would mean for our own legislation and the changes that are being considered today. Again, I won't go into the detail because I don't have time, but that's something that should be further developed. But what is very immediately relevant and critical is the EU defense against China's WTO claim, which was made last December. They asked for consultations, and then in March, and then again in April, requested the panel. So now there will be a WTO panel considering the EU's present legislation and whether it's in conformity with the WTO obligations of the EU. But the question is, what interpretation will the European Commission, because it's the Commission who represents the EU before the WTO, what interpretation of the expiry of that one provision will be presented to the panel? And will it be coordinated with the US approach? The other last element is timing issues. Again, this isn't addressed in the proposal or in the Council compromise, but it's sitting in the background. One question is, at WTO level, how important is it that we move quickly to adopt changes to our legislation before the WTO panel rules on the conformity of the present legislation. What are the implications for the panel ruling itself? What implications for further procedures at the WTO? And implications for European court litigation. This gets very complicated very quickly, very technical. So again, I just raised the questions here, but there are timing issues, and I would suggest that if you consider them carefully, there isn't necessarily the rush, certainly not a rush to do things inadequately. And that, I would say, is really the bottom line. Industry cannot afford to lose effective anti-dumping measures. We cannot afford to lose legal certainty. And we need to have the Parliament adequately consider the amendments to the proposal, even to the Council's compromise position. You have the same questions with European court litigation, but again, I won't go into detail on those. Thank you very much.
Bene, ringrazio l'avvocato.
Well, I'd like to thank Mr. Rissman for that very interesting presentation. Thank you for that. And now let's move on to conclusions. We've talked about wrongful practices and the impact, but we also have some issues with our own farming suffering from unfair competition from third countries, other countries which don't comply with the rules we have to comply with in Europe, and produce products of lower quality. So I'd like to give the floor to Arianna Giuliodori, who represents the Coldiretti organization, the #1 farmers representative organization. Well, thank you very much for inviting me. I'd like to go straight to the point and start with a concept of trade as a contribution to the well-being of all citizens. And I'd like to share with you the idea underlying Coldiretti's actions, i.e. that our work should be linked to the territory where people farm. It should make a contribution. Should make a contribution to social cohesion and create community. So reconciling the interests of the farming business and the wider interests of society has always been the key thing that we seek to achieve. We have about 5,000 products acknowledged as traditional specialities. We're the #1 in Europe for products with geographical origin and protected denomination of origin. And we have a really rich agriculture with a lot of added value, the highest in Europe, considerable resources, and there's a real focus on food safety. Italy has the highest number of checks and controls and the lowest number of positive checks for chemical residues, for example. So we together are taking a step towards this well-being, this prosperity for our country. And farming is attracting young people. We have an increasing number of under 35s involved in farming, because farming can give personal and professional satisfaction. But Italy is distinguished in another way as well. We have over 38 billion euros in agricultural exports, and the trend is on the increase. In 2017, over the past few months, we've seen a 10% increase compared to the previous year. Wine, cheeses, olive oil, cured meats, and we're well placed to construct the road to international trade. We're not saying we're not open to international trade. We do worry, in fact, when we see the Trump administration, for example, choosing which measures to take against the EU and its agricultural produce in order, he says, to make up for the damage suffered in the fight against hormone-treated meat. However, we see that when our products go to the US, people are very satisfied. And then there's the issue of Brexit as well. We're not really talking about this enough, but we think exports are going to drop by 7%, and that's a real worry for us. And I know this is one of the issues the Parliament will have to look into with a watchful eye. So international trade, yes, but not at any cost. Only if we don't jeopardize the extremely high standards we have in Italian and I think I can say European farming in terms of care for the environment and other standards. But these standards also impinge on people's rights. There was the agro-mafia report which came out recently, and the picture is absolutely desolate. We could talk about China and tomatoes, rice and olive oil. So these are key constituents of our Mediterranean diet. From reliable studies, we've seen that forced labor is used in China for agri-food production, and we are seeing an increase in imports of tomato concentrate from China, 100 million kilos. And it was very interesting to hear what the professor from Valencia was saying. We can see the same thing going on with rice. There's the Everything But Arms agreement, and a decision was taken to open up to those countries concerned. I mean, Italy is the #1 rice producer in Europe, and if you bring in vast quantities of rice, Vietnam has seen its exports to the EU increase by 489%. But what about the farmers? It's in our interests for this to be a lever for development, but we're seeing the same old multinationals there, and we're seeing the same practices being followed. And the same goes when it comes to Tunisian oil. And there's another agreement with the same political weight, but as ever, the Mediterranean farmers have to pay the price for this. So they are the bargaining chips in such agreements. So it's all very well to have a political discourse, but we need solidarity towards the farmers. So we need trade with real, genuine rules. But the rules need to comply with standards. They need to be genuine rules. When it comes to geographical indications, and the CETA agreement, people said this was a great victory. Finally, our geographical indications would get international recognition. But unfortunately for us, and we talked about 293 geographical indications and protected designation of origins. Well, on the final list, Italy only got 41 products, and France got 42 actually, but we won't go into all the nitty-gritty of that. I mean, if that's supposed to be a victory, this means that we've actually accepted coexistence with our famous cheeses such as Fontina and Gorgonzola. They have to coexist with existing brands and with brands that anyone wants to call imitation or whatever style and so on. What about Parmigiano Reggiano? The road ahead is clear. Parmesan has been recognized as a name, and products in Canada can be given that denomination. So should we be that happy about CETA? I have some doubts. And then there's a lack of transparency, which is probably the most serious problem we're currently facing. To talk about hard wheat, durum wheat in CETA, import duties for durum wheat are to go down to 0, as are exports of pasta. Now, Italy is the #1 importer of durum wheat in the world, and we export a lot of pasta. So it might sound logical, but it's not actually very logical at all as far as the Italian products are concerned. But what about another issue? In the final TBT the last Technical Barriers to Trade Committee of the WTO, the US, Canada, and Mexico have already raised an objection to the possibility that Italy wants to go down the path of indicating the origin of the wheat in their pasta on the labels on the packaging. Now, the procedure hadn't even started. I mean, what does this mean? Are we going to mix up products so they're mere amalgam? I mean, our standards are different. It's well known that durum wheat in Canada is grown in the autumn and winter, and it's and glyphosate is used to help it grow, and that's banned in Italy. And so there's a lack of transparency vis-a-vis consumers. It's not a question of protectionism, as the US, Mexico, and Canada have objected. This is something very democratic, respecting the consumers, because if we really go down this road of lack of transparency and liberalisation and lumping everything together, a complete amalgam, this will reduce phytosanitary standards, environmental standards, and others. And I think this might have a bearing on other agreements, such as those with Mercosur, Japan, and New Zealand. This would destroy the model we have been working so hard to promote and push forward. And others might be able to appropriate the added value that Made in Italy brings, and Italian farming and agri-food will be excluded. They would be marginalised. So Europe needs to look at international trade in a different way, and we hope the European Commission really will understand this. We hope that the Member States and the Parliament will understand what we're talking about. Unfortunately, that's not the feeling we currently have. Last November, for example, DG Agri presented to the Council a study on the accumulated impact of 12 trade agreements which aren't yet in application. Economic methods were used, but non-tariff barriers were completely ignored. Those are the ones causing us the biggest problems. And secondly, from the Mediterranean perspective, the study admits that the model chosen does not allow specific evaluation with regard to wine, oil, and fruit and vegetables. So, as far as Italy and the Mediterranean is concerned, we do have a few question marks about this. So, yes to trade, but we need fair trade which is fair, and we have a great deal to say and we need to be listened to.
A warm thanks to Giulia Dore for her speech. We endorse what she said, and you made some important points which will feed into our dealings with those who deal with matters in the field. When we take decisions, we need to do so in the best possible manner, and that's always been our aim. So that ends our event. Thank you to our guests. I would remind you of our position. If possible, we would like to have further contacts with experts and hear things from the horse's mouth so that we can come up with solutions which are beneficial to all. We are firmly convinced that the well-being of citizens, trade, the interests of companies and human rights are not just intimately intertwined, but all of these taken together mean that we need to come up with a synergy to work with in the future. As I said at the outset, I'm from the world of business myself. More than 10 years back, there was a conference for entrepreneurs where a marketing guru told us if you want to remain on the market, your companies either need to have fit products or sexy products, so there's no middle ground. Everything else is a waste. So we're talking about luxury products, sexy products from Zara, and so on. He thought everything else would go round the Swanee. You don't need to be particularly bright to see where this is going. We have to deal with the effects of globalization. Globalization didn't sweep down on us like a tsunami or a supernatural event. It's the upshot of clear choices which were made and pursued, maybe without thinking of the long-term consequences of what was being done. Products are deemed fit even though they are produced in countries where there is forced labour and a neglect of environmental and health problems. And sexy products are those which are the preserve of just a limited group of purchasers. What we can feasibly do is to tailor the world to fit human beings, in which products are accessible to all consumers, where consumers have a choice between products of various origins and at different prices, without failing to bear in mind that everybody should be able to purchase these products. Those who are jobless in Italy are the victims of the wrong types of choices. That's why products should become cheaper and produced elsewhere. That's not tenable in the long term, so solutions need to be hit on. It's urgent that we find solutions and answers and look towards the future, because the world ought to be steered by us and not others. Over to Giorgio. Yes. For those of us watching us on web streaming, this is something we've undertaken to do. We've set the ball rolling, and I would like to announce right now we will look at production processes in our next event. So production processes, the linear economy, the circular economy, the barriers to innovation will also be looked at, and the role of the government and the state will be examined, how they can help to achieve the targets to be set by governments, to have a shift in paradigm, a change of culture to ensure that social well-being and economic development can be enjoyed by our countries. I'll give you the link to sign up for our meeting in Rome. That will be on May the 23rd in Rome. So if you are watching us from Italy, you can look up the link and sign up for this event, which will be a whole day event on May 23rd.
Bene, direi che possiamo...
Right, we can knock it on the head here. Thanks to everybody both in and around the room for their strenuous efforts. Thank you to everybody who kept beady eye on us via the web streaming. As Giorgio said, we will continue to pursue these kinds of events in order that we have some kind of basis to act and to vote so that we can cater better to the real needs of our citizens.